I have to say, in the past year, we've seen a pattern of judicial nominees from President Biden, where over and over again, nominees have records of being partisan and ideological extremists, rather than men and women committed to following the rule of law. And looking at your record, I'm concerned that this nomination follows that pattern. You have had predictably knee-jerk left-wing views on the Second Amendment, on immigration, on the death penalty, on crime. I want to start with the latter. On the death penalty, you oppose the death penalty.
Senator, I've never let me say this before I became a judge, I never indicated any view regarding the constitutionality of the death penalty. As a sitting judge, I have had capital eligible cases. There were not seeks of death in those cases. I was fully prepared to apply the law in those cases. And the death penalty is constitutional. I would apply any Supreme Court and Second Circuit precedent.
But you've spent, 10 years as a federal judge? Have you imposed the death penalty in any case?
I have never had, I've had cases that were death eligible, and the process involves the local office and Maine Justice determining whether or not to seek the death penalty. The death penalty has never been sought in any of the cases over which I've presided. That process takes time, so I have presided over cases that were death eligible.
We've got limited time, so you have not imposed the death penalty in any case you presided on, correct?
It would have been unlawful for me to do so. That's correct. No
Okay,
case.
so let me start with my initial question. You oppose the death penalty?
Senator, I don't have a view that could be expressed, and I can.
You don't have a view. You spent years litigating. Let's say you led an amicus brief in Bays versus Reese, trying to challenge the death penalty. You participated in a Supreme Court panel in 2007 discussing Bays, and you also discussed Kennedy versus Louisiana. That happens to be a case I know well. I argued Kennedy versus Louisiana. It dealt with a truly horrific crime of a 300-pound man who brutally raped his 8-year-old stepdaughter, so much so that it left permanent, serious injuries to that young girl. Your notes for the panel at the time said, but the actual question and issue has nothing to do with innocence. If you have consistently litigated against the death penalty prior to your time as a judge, and yet you're not going to answer whether you oppose the death penalty or not?
Senator, my personal views have nothing to do with my application.
You didn't say, you said you didn't have a view. You may disagree that your personal views are relevant, but that's not the same thing as not having one. I mean, we're adults here. You oppose the death penalty.
Senator,
that's okay. That is a view people can have.
Senator, I can assure you, in any death case before me,
Okay, but you're not going to answer the question. But there's a difference. You can argue your personal views are irrelevant, but you're just refusing to tell them that. Well, let's shift to criminal justice generally. The Biden administration keeps nominating radicals when it comes to criminal justice. 2 of the senior officials of the Department of Justice are among the leading advocates for abolishing the police. The U.S. Attorney now in the District of Massachusetts, as a prosecutor, put out a list of 15 crimes she would not prosecute. And as I look at your record, you have a pattern on so-called compassionate release of releasing violent criminals. So, for example, in United States versus Stephen, the defendant had been indicted in part of what the Department of Justice called, quote, the largest gang takedown in New York City history. The defendant was one of 120 members of rival street gangs that were busted for racketeering, narcotics, firearms offenses. He was later arrested for violating the terms of his supervised release. Last year, you set him free, and that was bad judgment. And what's remarkable is that you released this criminal without even waiting to hear from the government whether he was a threat to society. In fact, the government planned to present you with substantial evidence from video surveillance footage and testimony from 2 law enforcement officers that he was unlawfully carrying a firearm and so was a threat to society. Why did you release a violent criminal without even waiting to hear from the prosecution about whether he was a risk to the community?
Senator Cruz, I have had many cases during the pandemic, as all judges have, regarding compassionate release in each of them. And actually, I think that was not a compassionate release case, if I recall correctly, but forgive me, I'm not sure. In each of those cases, I have analyzed the factors under First Step Act and 18 U.S.C. Section 3553A. By and large, the majority of cases, compassionate release was denied.
Okay, let me try again because my time has expired. If you would answer the question I asked you, which is why did you release this violent criminal without even waiting to hear what the prosecution had to say about whether he was a threat to the community?
Senator, I don't have a memory of that procedural posture. I have to say, my practice, of course, is to hear from both sides before issuing decisions, either in writing or orally. So as I sit here, I don't know what you're referencing.
Thank you.